on the diagnosis point, what does it add to call somebody suffering from delusional disorder if what you say is the only symptomatology they have is a non-bizarre encapsulated delusion and nothing else? That's my question for you. My question for Chris is, I actually agree with you that Riggins does the work, but what you haven't convinced me is that Cell is a disaster. Because Cell raises a conflict of rights, a conflict of interest, as do so many cases. There are so many cases that produce conundrums of just the sort you said, because we're always trading off interests. Until I see that the system breaks down and it's not working, and you conceded at the beginning it's not breaking down, I don't see that it's a disaster any more than any other conflict of interest case.
I'm not sure the diagnosis in that particular case adds anything. All I can tell you is I've seen now a number of cases where the diagnosis is argued interminably to talk about prognosis and what the data is. So some disorders, in other words, if you've got undifferentiated schizophrenia, your likelihood of getting restored is much higher than if you have delusional disorder. That, I think, the data is good on. So in those cases, it can make a difference. Some of it is just a nonsense.
What is the diagnosis, actually, the observations on undifferentiated versus non-bizarre encapsulated delusion? I mean, yes, we talk in terms of those categories, and the data are correlated, the prognostic data are correlated with that conclusion, but the conclusion is based on the underlying behavioral stuff. So what does adding the diagnostic term add?
Well, I don't think it's I don't know, I can't quite answer it in that way, but except that it seems to be legally relevant in terms of pulling together what research data exists, so that you can at least say research talks about this or it doesn't talk about that. It codifies it around a diagnosis. That's the way our research has been going. So we put people in these categories, we've done research on them, and we can say certain things about it. That's the best. I think a lot of times it's a waste of time. Just, you know, I've been in a case in releasing an insanity equity that they argued for 3 years about whether he had a delusional disorder or a psychosis not otherwise specified. Makes no difference regarding whether or not he should be released.
Well, okay, so I think, as you said, Riggins does the work, and that's one response to you. Why do we need anything beyond Riggins if we have those 3 criteria and they're met? But in addition, I really do think what I have there on the last slide is a fairly good positive argument against Cell. That is, it is created, as Loeffner demonstrates, that we've now had 4 Ninth Circuit opinions in Loeffner, the last one of which is 117 pages in its original version. Totally confused, going all over the place about what dangerous to self is, what dangerous to others means, whether it's okay to confine people. I think, this is my personal opinion, I think the government is acting pretextually here. If you got rid of the dangerous exception, it wouldn't have to do that. It could just say, look, we've got a felony case here, the Riggins criteria are met, we can force a Medicam, QED, or maybe the Riggins criteria aren't met. I mean, that's possible. Loeffner might be able to successfully argue that medication will not be an effective way of restoring the competency, or the side effects are horrible. But assuming Riggins criteria met, I think we shouldn't get into all this other stuff that Cell raises. And I think if you look at the lower court cases, you'll see there's incredible confusion. Not just about the dangerousness issue, but about what this special circumstances stuff is. The courts have no clue what's going on there. You look at decisions like the Grape, United States versus Grape, for instance. It's a great example of what I'm talking about. So,
the bind, at least in terms of the, I mean, when you see the issue about dangerousness, with one side arguing it is better to put somebody in seclusion and restraints, and then all of our hospitals, if we do that, we're going to lose our accreditation.
Right.
I mean,
I wanted to ask specifically about that point and where the court was getting its notion that physical restraints or solitary confinement